minute early. Welcome to the League of Women Voters of Curry County Informational Forum. Thank you. I'm Mary Jane LaBelle, president of the Curry County League. I'd like to introduce our VP, Lucy Labonte, who has arranged this forum and will introduce our speaker, Judge Jesse Margolis. Please turn off your cell phones until this is all over so we don't interrupt Jesse. Also, we have Coos County League members here. We have, oh my heavens, my head just went blank. Stand out and introduce.
Abigail Block, I'm the second VP of the Coos County League.
Thanks, Abigail. Are there any other league board members, whether Curry or Coos? We have Ann Schmierer up there who's at the table. And there's Evan Kramer, and there will be some more coming on in. I want to thank Jeremy for allowing us to use this. This is also a library function of education as well as the League of Women Voters. Now I'm going to read our about the League. We are a nonpartisan political organization encouraging informed and active participation in government, works to increase understanding of major public policy issues, and influences public policy through education and advocacy. The League does not support or oppose candidates running for elected office. Any voting person can be a member of the League of Women Voters. We have both men and women members and invite you to join. At the present time, we have unit meetings in all 3 cities. Membership forms are at the back of the room, as well as a donation jar. We hope you all, men or women, doesn't make any difference, will join the League. You don't have to do anything, but you get our great newsletter on what's happening in the county and the state and the U.S. For this forum, appreciation goes out to the Gold Beach Library, who is partnering with us for this informational forum. I will be attempting to record this forum, Due to popular demand, the League of Women Voters of Curry County hopes to put this on their website. So this is a first for me. I should have called you, Carl, and had you do this. So without further ado, I'm going to have Lucy come up, and Lucy will introduce our speaker for tonight. Thank you all for coming. Thanks. Hi, Charlene.
The introducer of the introducer of the introducer.
Yeah.
Anyway, I also want to say, as MJ explained, we're nonpartisan, and we ask that you leave your politics at the door. Judge Jesse Margolis agreed to come and act as a college professor to explain to us the judiciary system. This is educational, this is not political. And that is why he's here. To do this as a favor to me and to the League and to the library, to do an educational piece on how the system works. And basically, the idea came up because we're hearing a lot about courts in the news when you read it on the national level, and what's better than to start on the local level and learn about how courts work and move up. So on October 19th, we're going to have a Central County League meeting at Charlene's house, and our discussion will be on the League of Women Voters of the United States positions on the federal judiciary that they just came out with. The League only comes out with positions after study. That was a 2-year study. Once the study's done, all members read the study and we take a consensus to come up with the positions. So it's based on study and on facts, and it's non-biased. Both sides of an issue are always ironed out. So I wanted to explain that because I think it's really important. Folks need to know how we come up with our positions. And there are some of those positions in the US on the back table. I think some of our local league positions that over the years, we haven't done a study for a number of years, but over the years we've done studies on different issues and come up with different positions. We write them so they'll last over time. So I wanted to let everybody know that because I think it's important to know how the league functions. We are nonpartisan and we really appreciate Judge Jesse Margolis coming. He has been a judge here since 2007 and will now explain how this system works. Thank you.
Good evening. I am thankful for being given the opportunity to speak with you all tonight. I'm not here running for this position. I was just reelected to a 6-year term, a little bit less than a year ago. The last time I spoke at a League of Women Voters Forum was about 20 years ago when I first was running for this position. And that was a little bit different circumstance because I was running for office at that time. I was asked to talk about our court system, which I will do. I'll talk a little bit about the state courts where I work, some of the other courts in Oregon, and the federal court system. And then I'm also going to briefly discuss due process and the rule of law. I would encourage any of you who are interested in a more in-depth discussion of the rule of law or due process to do some research online. There are numerous law review articles on this topic with really in-depth discussions. There are some Oregon Supreme Court decisions which discuss these concepts in detail and the constitutional provisions that apply to these concepts. Very bright minds have delved a lot more deeply into this topic than I'm going to tonight, but there's plenty of information out there for those of you who are interested in this. In Oregon, we have numerous courts, including the state courts where I work, which are part of the Oregon Judicial Department. There are other courts such as municipal courts and tribal courts, which are not part of the state court system, as well as the federal court system. In our state court system, there are 183 circuit courts or circuit court judges throughout 27 judicial districts. The Supreme Court for the state of Oregon has 7 justices, and the Court of Appeals has 13 justices. The circuit courts are courts of general jurisdiction, which means they hear all sorts of cases. And we have one in Curry County. We'll get to that in a little bit more detail later. The Judicial Department in Oregon is a branch of the state government. The Oregon state government has 3 branches, each with its own role. The Judicial Department is part of the judicial branch of the Oregon state government. Our state court system serves about 4.2 million people and hears around 500,000 cases per year. Each of Oregon's 26 counties has a circuit court, including Curry County. Curry County is part of the 15th Judicial District, which includes Coos and Curry counties. We have 6 judges in our judicial district who are elected in these 2 counties, 2 of whom are mostly in Curry County and 4 of whom are mostly in Coos County. The federal system is separate from the state court system, and it operates as a relatively unified system as our state court system does. And it has a system of rules which usually apply nationwide. There's a complex relationship between state courts and federal courts governed by constitutional provisions in the law and federal and state statutes. Federal courts are courts limited to specific types of cases and controversies rather than being courts of general jurisdiction. I mentioned earlier that the state courts, state trial courts, like our those cases are cases in which there's concurrent jurisdiction. An example might be a crime occurring on federal land that could potentially be brought in a federal court or in a state court. The U.S. District Court for the District of Oregon serves the area corresponding to the state of Oregon, and it has courthouses located in Portland, Eugene, Medford, and Pendleton. I have very little to do with federal court. I didn't practice there as a lawyer, although I was admitted to the federal bar. I've only practiced in state court. I'm just telling you a little bit about that system so that you have an understanding about the relationship between our state courts and the federal courts. When I talk about courts being general jurisdiction courts, that means they hear cases regardless of the subject matter, amount of money involved, or the severity of the crime alleged. And circuit courts are courts of record, which means that the proceedings are recorded and the record can be used on any appeal. Most appeals in Oregon are on the record, which means the appellate court doesn't have a new trial. Instead, it relies on the record from the trial court and written arguments to decide whether the trial court's decision was proper. As I said, we have courthouses in Coos and Curry counties. The Coos County courthouse is in Coquille. There used to be one in North Bend as well, but that's been closed, and so all of the courtrooms in Coos County are in Coquille, and this is our courthouse here in Gold Beach. The state court system is a state system. However, the county does have some responsibility for state courts. Counties provide court facilities, like the courthouses, security, and maintenance for the court facilities. That's one of the reasons you might see some differences between court facilities in one county as compared to another county. For instance, Multnomah County has a nice, relatively new courthouse, and Curry County does not. I won't get into the details, but that's something that's been being discussed by commissioners over the years, and hopefully there will be continued discussions on the facilities and our needs for the future in both Coos and Curry counties. Our Court of Appeals for the state courts and our Supreme Court are located in Salem. If there's an appeal of any decision from our state courts, that goes to the Court of Appeals. In some instances, well, in the case of a death penalty case, that goes directly to the Supreme Court for automatic review. If somebody has appealed to the Court of Appeals, then they have the option to ask the Supreme Court to review the case as well after the Court of Appeals has made a decision on the case. In our county, we do have municipal courts. Other counties do as well. Those courts generally have limited jurisdiction, and decisions from those courts can, in some instances, be appealed to the circuit court. I haven't seen that happen very often, but it does happen on occasion. As I mentioned, Coos and Curry had 6 judges. We all hear a pretty wide variety of cases. This is a snapshot of the volume of cases that we saw in 2024. These numbers were provided to me by one of the court administrators, who I asked to just run some numbers so that we could have a picture of the types of cases that we're doing here. We have a pretty high volume of cases. We have court every day, usually starting with a juvenile cases that we hear, and it's there's a pretty steady stream of business. We always have things calendared. Sundays, things slow down a little bit. For instance, today I had a jury trial scheduled. I had planned to stop at 5 and come to visit with you all, but that case happened to be postponed, so I was doing a little bit of court work and mostly paperwork today. One thing that this slide doesn't show is the breakdown of case numbers between Coos and Curry counties. The numbers tend to be that Curry has a little bit less than 1/3 of the total, which reflects pretty closely what our populations are. And with state courts, the state court administrator does studies of workloads throughout the state, and that's how staffing levels are determined for our state courthouses. And we have court clerks and administrators who work there as well as judges. As I mentioned earlier, our state courts are courts of general jurisdiction, and this slide just shows some of the types of work that we do. I'll move on because I'd already discussed that a little bit. Due process simply is the legal principle that there should be fairness and justice in legal proceedings, which should be accomplished by requiring the government to follow established legal procedures before depriving any person of life, liberty, or property. Our legal system, at its best, protects individual rights and limits government power sufficiently to ensure due process to all. In order to do so, as I will discuss, our system of justice requires adherence to the rule of law. Due process is required by the Federal Due Process Clause of the 14th Amendment to the United States Constitution. While perhaps not important to this discussion, there has been Oregon Supreme Court analysis of the difference between the Oregon Constitution and the federal Constitution when it comes to due process. Those state and federal constitutional provisions are not equivalent. Generally, state constitutions often have more specific protections of individual rights than those contained in the federal Constitution. On occasion, Oregon Supreme Court justices have noted that grounding a decision on an independent interpretation of a state constitutional provision rather than the Federal Due Process Clause insulates the decision from possible review and reversal by the United States Supreme Court. What that means, in a nutshell, is the highest court in Oregon has, on occasion, decided cases using the state constitution and the provisions contained therein rather than the federal constitution, thereby foreclosing any possibility of United States Supreme Court review. Nonetheless, the due process requirements contained in the federal constitution may be imposed in a wide variety of scenarios and are applicable in state court proceedings as well, even though courts may choose to decide a case which implicates due process concerns on a more specific law provided by statute or the state constitution. The rule of law is the principle that all individuals and institutions are accountable to the law. Law should be applied equally to everybody. Every lawyer and every should appreciate the rule of law, and by their actions should demonstrate that the rule of law is meaningful, consistent, and reliable. That includes not using words or actions which diminish the law or our system of justice and its applicability to all persons equally. Our system of justice and the law on which it is founded, including the Constitution of the State of Oregon and the Constitution of the United States, are only as strong as the people who stand up for them. The protections provided by our law are not self-executing. They require the people, including those who work in the legal system, to be guardians of our system of justice. Due process and the rule of law have a long history, in fact, dating back at least to Aristotle, who contrasted the rule of law with the rule of men. More recently, the 14th Amendment to the United States Constitution addressed due process. That amendment states in part the following: "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of the laws." The rule of law is an idea and an ideal that is as important as the ideal of democracy. Most would agree that people in power should only exercise their power within a constraining framework of law and norms, rather than in an arbitrary or purely discretionary manner. That is largely what the rule of law requires. The rule of law is not just about government. It also requires that citizens should respect and comply with legal norms, even when they disagree with them. It means that when their interests do not coincide with others, they should accept legal determinations of what their rights and duties are. It means that the law should be the same for everyone, and that no one is above the law, and that everyone has access to the law's protections. All of this requires not just the independence of the judiciary, the accountability of government officials, the transparency of public business, and the integrity of legal procedures. It also requires the support of the people. That support includes an appreciation by all that the law applies to everybody equally, that people in court win some and they lose some, but that doesn't make the system illegitimate. It requires that people have confidence in our legal system. This is not to say that the legal system can't be improved. In fact, we have a system that allows for that, and a legislative process that allows for changes in the law, and the law changes frequently through that process. Aristotle discussed the question of whether it was better to be ruled by the best of man or the best of laws. Philosophers who followed people like John Locke in the 1600s, Montesquieu, who was a French judge and philosopher who influenced the founding fathers of the United States in the 1700s, and Lon Fuller, who was an American legal philosopher and professor at Oregon, Duke, and Harvard in the 1950s, continued to explore these ideas. And now, as we strive to not only preserve our democracy, but improve it, the continued voices of those who seek to preserve or improve the best mechanisms for the pursuit of justice and fairness to all is as important as ever. In my view, having a well-functioning court system provides the best chance for maintaining the right to due process and the rule of law. rule of law has the effect of making power less arbitrary, more predictable, more impersonal, and less coercive. It establishes what Fuller called a bond of reciprocity, a mutuality of constraint between the ruled and the ruler. There are those who have argued against the rule of law. These criticisms go back at least as far as Plato, but I have yet to hear or read any convincing argument that our democracy and society are not well served by a court system that upholds the rule of law and a government and court system that respects the due process rights of individuals. In preparing for today, I created a slideshow. I borrowed a little bit from some presentations I'd given to high school classes years ago, and I've talked to some other organizations as well. In those talks, it was easier to determine who my audience was likely to be. I think this might be a more diverse group, and I'm happy to see you all here today. I'm going to take questions in a minute. I had also prepared a little bit to talk about precedent, what that means, and a little bit more about federal courts. But I think, and particularly how precedence applies in those courts. But I think I'm going to leave that to you. If you're interested in that, it's easy to find charts online that show which courts are bound by which other courts. I will say that stare decisis, which means it's a Latin term meaning let it stand or let the law stand. There's someone here who might know that better than me. Let the decision stand, thank you. I think that's probably the best translation. Our legal system has a long history based upon that concept, and I think it relates well to the topic of the rule of law and due process and having some consistency. But that concept is in application much more nuanced than you might think. And I'm not going to get into that in too much detail, but we think, well, when a case has been decided, say by the Supreme Court, that should be the end of the line, but that court, as other courts, can change its view of or interpretation of the law over time. And there are some very strong examples of that. One that comes to mind is Plessy versus Ferguson, which was overruled by the Supreme Court in Brown versus Board of Education. And that had to do with the idea, well, in Plessy versus Ferguson, that separate could be equal, basically, and in Brown versus Board of Education, the Supreme Court came to the conclusion that separate did not necessarily mean equal, and from then on, schools could not be segregated anymore. So that's an example of the Supreme Court over time changing its interpretation of law, and there are many other examples of that, but that's the one that probably most of us have some familiarity with. Why does this matter to you? This is a slide that I took from presentations that I've given previously. And high school kids have read this, and Rotary members have read it, and Seroptimus Club members have read it. But the same holds true for all of us. These are your courts. The courts impact you in many ways, even if you never go yourself. These courts have some influence on how our businesses operate and how our society operates. And so all of this can have an impact on you, even if you're not a litigant yourself or not a juror. I will take questions. Please don't ask about pending cases. And there's already a hand up. Please don't ask about how I might decide a future issue. And please do not ask my opinion on political topics. One thing I will say is that I've touched on some concepts that are applicable to politics today, but those concepts are applicable to everybody, regardless of your political viewpoint, regardless of whether you're red or blue or whatever. It's all the same for everybody. That's my point. I would like to take questions, but please keep in mind the constraints on me.
Judge Margolis, is it true that in order to be appointed a judge or be appointed or elected, you have to be an attorney who deals in courts, and after you've been appointed or won the election, do you have to go through special training to be a judge? Well, give us an idea about that.
Well, for state courts, you have to be a lawyer.
A lawyer?
An attorney. You don't
Oh, a lawyer.
necessarily have to practice in any particular
Oh,
area of
okay.
law. And a state court judge may be appointed if a position needs to be filled, if there's a vacancy in the position, or may be elected. If there's an appointment, the person who's appointed generally is going to be running in the next general election after the appointment. The municipal courts historically there's not been a requirement that the municipal court judge be a lawyer. I'm not sure whether that's changed. I know there's some talk about that, and I think in the event that they're not, there might be some limitations on what the municipal court can hear.
Thank you.
Okay, I'm gonna work my way from my left to my right. Yes.
Could you, it's always not unclear to me the difference between common law and tort law. Could you talk a little bit about that?
Well, there's common law that relates to torts. And,
Okay.
So,
That's probably why I'm confused. But
yes, so common law sort of it's complicated, but it's the history of our law dates back to, I'm not sure how long, but it goes back way before the founding of this nation. And there are common law concepts, and then that are potentially applicable, and particularly in equity. And then there is statutory law and case law. And case law can reflect what is in common law. So torts relate to injuries and cases where there can be damages sought for injuries, as opposed, say, to criminal law, which relates to alleged crimes.
so common law is kind of history. It's how courts have decided in the past. It sets a precedent, and that's the way things are decided now. And then there's something
Yes,
else that's like
basically.
an absolute law that isn't historical as much as it is.
Well, the legislature can create law
Oh, okay.
that isn't common law, it's legislatively created law, statute. I'm still gonna work from the left to right here, yes.
Are Oregon Court of Appeal judges, are they elected or are they appointed?
Yes. Just similarly to state
Or
court,
vacancy?
to trial court judges, except trial court judges are elected in the judicial district where they're going to serve. So, for instance, in the 15th Judicial District, which is comprised of Coos and Curry counties, the judges are elected by the voters in those counties. And then for the statewide positions, it's a statewide election, Court of Appeals. Yes.
You mentioned that there are certain rulings that the Oregon Supreme Court will rule are just applicable in Oregon, so U.S. Supreme Court won't get involved. What's an example of that, of a kind of issue where that has applied? Because it seems like everything these days gets sort of nationalized in terms of issues. So I'm just curious what kind of item can remain at the state level.
Well, we've been talking about due process rights, so there could be a fact pattern that implicates due process rights. in state court where the court could decide that issue based on the state constitution rather than applying the federal constitution. So due process rights can be implicated in a very, very wide variety of circumstances. Yes?
So if a decision is made by the court and it is appealed to the highest level and a final decision is made, what enforcement mechanisms are in place to ensure that that decision is carried out?
Well, it really depends. And I think that question is applicable even with a trial court decision that is an appeal. There can be enforcement issues. And there can be contempt proceedings in the event that a person is willfully disobeying a court order. And so that's one enforcement mechanism. There can be civil contempt proceedings and criminal contempt proceedings. So for example, a person in a civil case might bring a contempt action on their own, a civil contempt action, or the state, the prosecution might bring a contempt action, say in the event that somebody's not abiding by a Family Abuse Prevention Act restraining order. There could be another proceeding that's a quasi-criminal proceeding, a contempt proceeding, which means it's not really a crime, but it's pretty close, and the potential consequences are very similar to the consequences of a criminal proceeding, including incarceration and fines. We'll go to the front
I
here.
have a quick one.
Yes.
So if I understood you right, you said that you do not have to be an attorney first to become a judge.
That is not true for state courts.
That's not true for the state courts. Which courts, does that apply to small claims court?
No.
Federal court?
Small claims are heard by state courts. Certain courts hear small claims cases through the small claims division, and the small claims that are heard in state court are heard by judges who are lawyers.
So
And
what
so that would
judges,
apply to, at least historically, to some municipal courts where it was not a requirement to be a lawyer to become a municipal court judge.
so what positions are usually not, what judge positions are usually not a lawyer first?
The municipal courts are the only example that I am aware of.
Okay.
Yes?
On one of your slides, you mentioned several cases that were involving mental illness, I believe. And I wonder how that impacts a court case. If the subject of the court case is possibly mentally challenged.
Well, the two primary ways that comes before the court that come to mind are civil commitment cases, which are actually about a person who is allegedly mentally ill and is unable to provide for their own basic needs, or they're a danger to themselves or others. And in those cases, the state is seeking typically to have somebody committed to the state hospital for some period of time. The other way that it comes up is frequently is in criminal proceedings. And in criminal proceedings, if a person is suffering from mental illness, they may not have the ability to aid and assist in their own defense, which will typically delay the proceedings until they are able to aid and assist. And the court has some power to order that the person engaged in treatment, sometimes hospitalization. There's some federal law on case law on that recently, which limits what we can do in the state of Oregon in terms of committing somebody to the state hospital for restoration. But in some instances, we can do that, although the time limits are now limited by that federal case law. The other way that it can come up is that it can become a defense or partial defense to criminal activity. So if somebody doesn't have the ability to form a specific type of intent in a criminal case, that can create a partial defense. It's not really a complete defense, but it is potentially a partial defense. And that means that a person might be found activity that they were convicted for would be different than someone who's
So who
convicted on.
determines that this individual is mentally ill? Does the judge have to be convinced, or does a jury have to be convinced, or both?
Judge typically, well, in most instances, the judge is making that decision, and typically based upon evaluation. Sometimes there are competing evaluations. The prosecutor may have an evaluation performed on a person, the defense may have an evaluation performed on a person, and then the court has to decide what findings the court will make depending on the evidence, application of the law, the evidence. Yes?
With the numbers of cases that Curry County or the circuit hears, and the number of judges, is that number consistent and equitable across circuit courts in the state? And what is the number of judges? Is that determined by the number of cases, or how does the state assign how many judges per circuit?
Well, the state doesn't really assign judges per circuit. Because, well, first, each circuit has at least one judge. And there are a certain number of judges for each judicial district. The legislature can increase that number, which it has done recently, and that's been done based on workload studies, which are more complicated than simply the number of cases and the number of judges and number of staff. And those positions where they've added judges, they've also added some staff because we have to have enough staff for each judge to help with the work that they're doing. So the workload studies are done for staff and for courts, and the legislature has used that, is my understanding, for creating new judicial positions. None in our judicial district. The last new position, I think, was created in North Bend, probably, I think it may have been in the 70s.
Well, I guess that was gonna be my question, is because what I see across the state in terms of equity in all kinds of parts of our government is like, you know, you look at the schools and the formulas that are used to fund schools. There's so many complicated factors in that. Usually those formulas apply across the board, but then in a rural area, to be able to stretch your resources, you're expected to do it the same way you would, anyway, where you have a bigger population. So I guess my question is the state doing that in a way that is equitable for rural courts?
That may be getting too much into politics. I am happy with our staffing levels personally in our courts here, and I think that we're able to handle our workload. That staffing level has been adjusted over time, and I think our administrators do a really good job of that. I don't have a big part in that. I'm not an administrator, and the state courts have administrators both at the state level and at the trial court level, and they're much more familiar with the ins and outs. But for me, I'm really happy with our staffing and our staff. Yes.
I thought the answer was gonna have to do with caseload, but when you're running for election as a judge, there very often is not opposition. Is that a professional kind of respect piece, or is that there's not enough people willing to do it piece? Where does that come from?
I would imagine that varies from area to area. My first election was a contested election. That does happen. Often it doesn't. I think it really just varies from one set of circumstances to the next. I do know that there have been a lot of retirements in the last 6 or 7 years, and many of those retired judges have gone back into private practice or gone on to do other things other than being a judge. And there are a wide variety of reasons for that. I think historically, salary hasn't been competitive. The pressures of doing this kind of work can wear on people. Judges
jail space in Coos and Curry County affect the judicial system very much?
I'm sorry?
Does the lack of jail space in both counties affect the judicial system? Is that a fair question to ask or not?
It's fair. I think it impacts the decisions that we make as judges because we have to take that into account when we're sentencing people and coming to the realization that a person may not do any of the time that they're sentenced to, or they may only do a small portion of it. So that can impact sentencing decisions, not just locally, but statewide as well.
So if the jails had more room, there might be different decisions.
Perhaps. You know, with felony cases, we have sentencing guidelines, which are more than just guidelines. They have to be followed, and those provide parameters for the amount of either local jail time or prison time that a person does based upon a certain criminal history score and that person has, and the crime seriousness level of a particular offense. So in those felony cases, I don't think it has much impact because a sentence will be imposed pursuant to the sentencing guidelines, and then whether or not that person serves it really isn't up to the judge. It doesn't impact that decision. It's just something that happens or doesn't happen after the sentencing.
Thanks.
Yes, does the principle of due process include something to do with timing or the promptness of a case being heard or a case being adjudicated?
Yes. And if you look back to that federal constitutional provision, it is exactly what it says, and it's applicable in, I think, in any circumstance where you could think of that it might be applicable. So I think due process would require that a person, say, who's incarcerated, have timely hearings under the law.
Well, what happens in Oregon if there's not enough, I guess, defense attorneys or court-appointed defense attorneys? How does that work with due process then?
That has been an issue, and another issue can be whether or not a person can have a trial within a reasonable period of time, especially if they're incarcerated. And we'll start with that. In the instance that a person is in custody, they have a right to be tried within 60 days. If the court can't accommodate that right within that time frame, the person is to be released. There are some exceptions to that rule, but that's what's supposed to happen generally. And the reality is often somebody is actually being held pre-trial has a serious enough case that their lawyer doesn't want the trial within 60 days. The defense usually wants it farther out than that, so they have enough time to prepare. But that's one way that comes into play. There's a statutory provision, which we refer to as the 60-day rule.
Judge Margolis, you drifted from the microphone.
I'm sorry. Thank you. The issue of not having enough defense attorneys has been a problem statewide in the recent past, less so in our county, although we've had a couple of people we have not been able to find attorneys for, not as we speak, but not too long ago. And courts have grappled with what to do with that, and I think it's dependent on the seriousness of the case. And there have been cases that have been dismissed because of that, and cases where people have been let out of custody because of that, because they, are potentially sitting too long without counsel.
So too long is in the eyes of you as the judge, or is it what?
Yes, or I think there are judicial districts that have developed some policies in relation to this. And one thing I would mention is that, I make decisions as a judge, but almost universally any decision I make isn't the last word. Any litigant can ask to have one of my decisions reviewed by the Court of Appeals, and in some instances, the Court of Appeals can look at a decision really rapidly.
But again, the timing for due process, how long does the Court of Appeals normally take to make a ruling after you make a ruling?
Well, normally, it seems like it might be a year and a half or 2 years, but But there are instances where, say in juvenile law, where they're really pretty rapid with those decisions. And some, I don't know the timelines exactly, but I think it could be within months in some instances.
Thank you.
It is a problem. It's recognized in the trial courts, and I think the legislature has grappled with this. Probably read about this in the recent past. Since you've asked this question, I assume you know a little bit about it already. Yes.
You had mentioned that there are some cases that have both federal and state jurisdiction. Who decides? Is it the attorneys that decide to go state or federal, or the judge, or what?
Either one can happen. The state, let's say it's a criminal case, the state might decide to proceed in state court as opposed to federal court, or vice versa. Or in civil cases, a litigant might decide to file in federal court versus state court, assuming federal court has jurisdiction. And then in some instances, a judge decides when a case is removed to federal court from state court. There might be instances where that happens as well. Yes?
I wonder if there's some general standards of what types of cases are held between the county, state, federal, kind of an overview.
Could you repeat your question, please?
What kind of cases are generally heard in county, state, federal court?
Well, first of all, when we're talking about the court in Curry County or the court in Coos County, those are state courts. So they're part of the state court system, which are courts of general jurisdiction, which means really any type of case. We don't hear tax cases or federal cases in state court, but it could be anything from small claims up to multi-million-dollar lawsuits. It could be anything from a traffic ticket to a death penalty case. Family law, juvenile law, probate, civil commitment cases, the list goes on, everything. Yes?
You mentioned that the state constitution and the federal constitution may have some probably small differences, but differences. And I'm curious about how some cases they'll be heard on appeal to the state Supreme Court, and then they'll be appealed to the federal Supreme Court. I'm curious if it's based on the differences in the constitutions, or do they just, how do the judges decide which cases they're gonna take? Besides, if that was one of the-
So for the most part, a case that's heard in state court and is decided in state court stays in state court. When there's a federal question, say a federal constitutional question, there could be instances where the Supreme Court might decide that it would hear an appeal from the state court, but that's rare. For the most part, that does not happen.
So if I wanted to have something go to the Supreme Court, I would file with the federal court. So that it would go to the district court?
Well, it's not necessarily.
I'm just saying, I'm just trying to understand the system.
There can be, so generally, they're separate systems, and generally the state courts are
Okay.
deciding the state court
I
cases.
see.
And in the federal system, the federal courts are deciding the federal cases. But there are exceptions to that. They're just, I believe they're rare. So there are cases where state court decisions can be appealed to the United States Supreme Court. Yes?
I'm trying to have this not be political, but if I want to file in a federal court where I think the judge is going to be in my favor, there's nothing to keep me from, even though I'm in Oregon, filing in Texas or filing in Illinois or any place, if I think I'm going to get a benefit. Now, the only way that that's going to get equalized then is at the appeal level, right? Because it may be a fait accompli that I'm going to have a sympathetic ear if I file in one particular court. So that can only get balanced at the appeal level?
Well, first I'll say that judge shopping is frowned upon and lawyers aren't supposed to do it. Second, I'll say that you can't necessarily just file wherever you want. The court has to have jurisdiction over the subject offense, and the venue has to be correct. It doesn't mean you couldn't file, but you may not be in the wrong court for very long if you're filing in the wrong court. And I'm not going to speak as to
No, I'm not
where the
trying to
best
make a
places
point
are, how to use it.
I'm trying to understand if there's a mechanism by which that can be rectified, that's all.
I can't answer that question. It's a good question. Yes.
Probably some people in here already know this, but does Oregon have the death penalties, and is that something that you would decide here in
I
the
have
state?
decided it.
You have decided that? Okay.
Yes.
I have a really league-specific question. So we have a voter information website called Vote 411, and we invite everybody who's running for public office in the state to post information on Vote 411. We ask them usually three questions, and if they answer those, then they can post information about their campaign. We get terrible levels of response from judges. I can think of a couple reasons for that, and one is that maybe they're running unopposed, and another one is that maybe they fear the questions might be political or commit them to positions. We try really hard to frame questions so they go to your experience and general philosophy of the of your position. Is there something you think we could do to attract a better response from judges in our approach to this?
Perhaps reaching out personally to judges might help if you try to explain what it is that you're after. I've run unopposed 3 elections now, and even though I've run unopposed, I've put a candidate statement in the voter's pamphlet and paid for it, just to try to get information to people out there about me, even though I didn't have any opposition. I personally think it's important, but I can't say, since I had a contested election, that I provided that information to the League of Women Voters either. You're probably more likely to get responses from people who are running in contested elections than from judges who are unopposed. But I do think that information is equally important, even when a candidate is not facing opposition. I'm here to talk to you all today, not because I'm running, I'm not, but to provide information to all of you and to help provide some education and let everybody know what I think is important about what we do in state courts.
And Vote 411 is free, by the way, so, if you don't want to pay for the official ballot pamphlet, you can.
That may be a good selling point as well.
Okay, thank you.
Yes.
We were considering, it was being considered heavily about putting offshore wind farms here. They're pretty well shot down now, but there was some question about federal jurisdiction and rights of the state to say we have these protected things in place, and the feds can't just walk all over it. I think that's an interesting topic in the sense of, how do you work with the feds if we're so powerful we gotta fold to them, or how does that, any thoughts on that?
My thoughts are that I am not working in federal court, so I do think it's an interesting topic, and I don't think it's been litigated in terms of the offshore wind in this area, but I would imagine there is probably some case law on that topic federally. I have no court.
Tribal and everything else?
Yes.
Oh, I think the Department of Land Conservation and Development had state attorneys that were collaborating with them on enforcement of that state law. So I don't know where those state attorneys, what part of the Justice Department they would have been in, that were working with PLC, but.
I don't know much about that.
That's the county commissioners in that court system. That's a whole different courts. People don't know county commissioners are actually judges in a way too.
You mean the land use
Yeah,
decisions?
the land use is a whole,
Right.
that's not your court system.
And I didn't talk about this, but in addition to state courts, we have administrative bodies that decide certain things like land use planning, which those issues can end up in court as well. And some of you may be familiar with the Department of Motor Vehicles, which has administrative proceedings related to driver's licenses and other things. Courts don't deal with all of these issues. Sometimes administrative bodies deal with them. Yes.
I have another one that has always puzzled me as an individual and puzzled students when I was teaching. The state legislature has lawyers that review things before they go out onto the floor. But with our initiative system in Oregon, they're not reviewed before they're put on. They're reviewed after the fact. Like, what's the conversation on that?
I imagine there's a lot of conversation. There are instances
Sorry, what is the
where
conversation within the Justice Department about that?
I wouldn't know, but courts can review ballot measures as well. So that happens on occasion. So there's the potential for review if somebody complains about a title or a measure, the language contained there. Yes.
This is the last one, okay? Last question.
All right.
So there's a lot of discussion now about diversionary programs versus incarceration. Can you add any insight that would be helpful, you think?
Well, I think that might be a political topic as well, but I think what you're talking about is particularly in relation to drug offenses and the changing landscape in that regard. I think the legislature is just trying to be responsive to what's being seen on the ground, and the law is changing as it does slowly, and the courts are, I believe, following the law.
Okay, thank you. Thank you all for coming. We will be doing more informational forums, so keep your eyes open for them. I'm glad to see so many of you here. Thanks for coming. I'm thinking this is very light and everybody's up there. Yeah, thanks.
Of course, I don't want to do anything stupid here.
Okay, let's turn it off first.
Okay.